Good afternoon, everyone. My name is Kady Matsuzaki. I'm an English major in CAS, and I'm also a pre-law student. And the title of my project is The Language of the Law, Supreme Court Opinions, the Constitution, and American Common Law. So there are two basic elements which many civilizations exhibit, law and storytelling. Humans need both in order to make sense of the world. But law can be a tricky thing to kind of read and understand if you're a common person who's trying to read a legal text. But as an English major and pre-law student, I wanted to find a legal text that had narrative aspects, which I thought would make the text easier to read, which is kind of how I decided upon Supreme Court opinions, where I found this nexus. So I found this combination of law and literature in Supreme Court opinions. And for those of you who are unfamiliar, Supreme Court opinions are written by a single justice after a decision has been reached by the Supreme Court, and they might be supplemented by any complementary or dissenting opinions written by other justices on the court. So including narrative aspects in these opinions serves to help increase the common person's understanding of our nation's law and its development, because usage of these tropes and devices helps to universalize the legal jargon and reasoning that goes on in opinions, which will thereby familiarize the common person with the decisions. And if the common person can read or understand these decisions, then their idea of the common law might be changed or altered. Now, what exactly is the common law? So according to Noah Webster of Webster's Dictionary fame, the common law is the unwritten law, which has authority because it is known by all and has survived generations through its ability to adapt to societal conditions and ideas. Oliver Wendell Holmes Jr., who's the former Chief Justice of the U.S. Supreme Court, adds a narrative-like aspect to this definition, writing that the common law embodies the story of a nation's development. People have to know what the common law's history is in order to know what it could become as well. So the U.S.'s legal narrative, as told in part through Supreme Court opinions, has a direct influence upon the story of American common law. Justices, through their use of these literary devices, are making their decisions accessible and thereby interacting with and guiding how someone thinks about a particular decision or issue, and therefore their common law understanding. So keeping these ideas in mind, I decided to read and examine landmark cases and their corresponding written opinions. So landmark cases are ones that people are still talking about today. I was particularly interested in three topic buckets: abortion rights, discrimination based on race, and discrimination based on sexuality, just because they've introduced morality as an aspect of culture into the law. So therefore, I picked Roe v. Wade, Planned Parenthood v. Casey, and Whole Women's Health v. Hellerstedt, which all had to do with abortion rights, Korematsu versus the United States, and Trump v. Hawaii, which had to do with discrimination based on race, and Lawrence v. Texas, Obergefell v. Hodges, and Masterpiece Cake Shop v. Colorado Civil Rights Commission, which all had to do with discrimination based on sexuality. So all of these cases have had a significant impact on how society views and talks about the issues that they concern. And so once I had chosen the cases that I wanted to analyze, I read through the written opinions as I would any other literary text, with an eye for devices, tropes, and techniques. So these are some examples of things that I found. So first, explication and context. Novels always begin with explication, which is just background information, and opinions are no different. They always start off with the facts of the case. And this can prime the reader for what is coming later in the text, which is the legal reasoning. But it also provides context for the reader and might elicit sympathy for the plaintiff or one of the involved parties. So for example, in the Obergefell v. Hodges majority, Obergefell, who's pictured here, his situation is described as thus. Obergefell and Arthur decided to commit to one another, resolving to marry before Arthur, who's Obergefell's partner, died. To fulfill their mutual promise, they traveled from Ohio to Maryland, where same-sex marriage was legal. It was difficult for Arthur to move, and so the couple were wed inside a medical transport plane as it remained on the tarmac in Baltimore. 3 months later, Arthur died. So this explication is very factual. It has no emotional flourishes of any kind, but it still conveys sympathy for Obergefell and might make the reader more willing to accept the final decision of the case, which was the federal legalization of gay marriage. Justices will also use analogy and hypotheticals in their opinions. So according to this protest poster, the burden is undue. But what does that mean? So Justice Breyer, in his majority for Whole Women's Health v. Hellerstedt, which is the abortion rights case which this sign concerns, he used a hypothetical analogy to clear up the legal term undue burden. So he compares the burden of accommodating a 500% increase in patients to an abortion providing facility to an equivalent increase in customers to a grocery store. Now, we've all stood in an unbearably long line at the store. It's horrible. So it becomes abundantly clear just how awful and unfair this increase in patients would be to any woman seeking an abortion, which thereby clarifies what an undue burden really looks like. So Breyer's hypothetical serves to relate a line of legal reasoning to an everyday situation in order to facilitate more common understanding. Justices will also use imagery and metaphor. For example, in his dissent for Korematsu versus the United States, which has to do with Japanese internment during World War II, Justice Murphy calls Executive Order 9066, which you can see up on the screen, a descent into the ugly abyss of racism. Now, to Murphy, it's very clear that the government crossed a line and acted on its racism, and this act of exclusion has pulled the government into a hole so deep that the bottom cannot be seen. So rising from an abyss unscathed is unlikely, and to Murphy, it seems that it will be difficult for the government to rise above such a racist action in the future. So his use of imagery and metaphor served to clarify his point and indicate the consequences of this particular decision. So long-term legal ramifications might be difficult for the common person to kind of visualize or conceptualize, but by imagining an ugly abyss as compared to institutional racism, it kind of makes that a lot more clear for anyone reading the opinion. Tone can also have a large influence on a reader's experience of a novel. It's the same goes for a written opinion. So you can see here Antonin Scalia, who is a justice well known for his very pointed, very distinctive tone during his opinions. And the quote next to him is an actual quote with all of the punctuation included from his dissent on Obergefell. How can a better informed understanding of how constitutional imperatives, whatever that means, define whatever that means, in urgent liberty, never mind, give birth to a right? So here, Scalia's casual tone and use of slang makes for a really easily digestible, almost enjoyable bit for the press or the common person to pick up on, understand, and kind of process. But it's a little bit problematic in that the most easily read opinion in the Obergefell docket is one that is pretty deeply biased, pretty skeptical, and almost angry with the decision of the court, and that can lead to a skewed version or vision of what the court was actually trying to prove in its majority opinion. There are also some modern influences that you can see. So in her dissent for Trump v. Hawaii, which is the travel ban case, Justice Sotomayor cites a few of Trump's tweets, two of which you can see here on the screen. So there are just these new modes of communication and new avenues for justices and lawyers to gather facts. So this greater dissemination of information through social media can lead to a changing conception or idea about what our law is and what it should be. If you are just the common person seeing these tweets in real time, they came out before the decision came out, it might change how you think about the final ruling on the case. And it is now difficult or even impossible to hold these common law ideas in a vacuum. Seeing things like this on TV, on social media, on the internet will all influence how people now and in the future think about the Supreme Court decisions and American common law. So I just wanted to leave you all with this quote from Lawrence v. Texas. As the Constitution endures, persons in every generation can invoke its principles in their own search for greater freedom. So now, Justice Kennedy, he's touching on a key point here, greater freedom. So in searching for greater freedom, the common person must be able to understand what freedom has meant and what it can mean. So through the use of literary devices to convey the court's interpretation of the Constitution, justices are recording the history of freedom and, in general, the history of American law in ways that everyone can understand. Therefore, these judicial opinions are appealing to a common law sensibility in order to engage with what society demands of the Constitution and its interpreters, the Supreme Court. The unelected justices are demonstrating that there is just as much of the people as any elected representative through their writing style. They want the common person to understand the laws and decisions that govern these culturally relevant issues. And this understanding will in turn further encourage conversation and debate among anyone. So the narrative surrounding topics like abortion and the treatment of minority groups, it's not monopolized or ended by the Supremes or a Supreme Court decision. An informed public can also contribute to this legal story, if you will. And if the Constitution is the root of the United States' law and legal narrative, then Supreme Court opinions allow it to further bloom into a narrative body of law that the present and future common person interacts with as a part of their own story. Thank you. Yeah, what's up?
So for each of these court cases that you looked at, these Supreme Court cases, did you look at all of the opinions, dissenting and majority?
Yeah, I read through all of them. Yeah. Quite a lot of reading, but it's not something I'm not used to.
Was Justice Scalia a standout as far as like how much tone is conveyed in his opinions, or are there other justices that do something similar?
Out of like the cases that I've read, he's definitely the one who has the most personality. And originally, when I was kind of researching what I wanted to read in terms of like a legal text, I had read some news article that was talking about Scalia and how like distinctive he was, and that was kind of one of the things that drew me to reading the opinions, was that I knew that there was going to be something there that might like kind of expand into more analysis. Yeah.
So one of the cases that you analyzed was the like Japanese internment in the 40s, and then gay marriage in the 2010s. Was there a big difference, or did you notice any big differences between the like old case writing and the new case writing?
I think in terms of just basically like length, there's a lot more precedent now than there was before, so lot more cases for them to reference. So more modern cases will be longer. But in terms of writing style, I wouldn't say that there was too much of a difference, which to me was actually really surprising. I thought that modern opinions might have a little bit more like flourishes, but like the Korematsu one had the ugly abyss. Like that was something I really wasn't expecting from. You would think that they'd be a little bit more stodgy, a little bit more traditional, but that actually wasn't the case. And just the way that some of the justices who disagreed with the majority finding of the court was that that the 9066 was constitutional. I wasn't really expecting a lot of pushback in terms of like that was racist, but that was clearly there. And the same goes for like the gay marriage case, where there was a lot more of kind of like, I'm not against gay marriage, but I don't like this decision. And it was a little bit more kind of like hedging their bets, which I thought was interesting. So that was kind of a difference. It wasn't really like a continuum or like a spectrum, but it was more like there were just certain things that the justices would handle more carefully when they were writing their like dissents, for example.